I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introduction to open meeting law, our latest round of video tutorials and other lessons on freedom of information laws in New England. If you haven't already, please check out our previous lessons on public record laws and the Federal Freedom of Information Act. All lessons are available to view at nefac.org/FOI guide. In addition to more video tutorials, you'll also find there other helpful resources such as common Q&As, notable case law, and an FOI legislation tracker. This round of lessons is brought to you by NEFAC with help from the Society of Professional Journalists Foundation, the Rhode Island Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. We're grateful for everyone's support. Thank you. Now, here's NEFAC's Emily Sweeney to introduce you to your instructor.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is part of our ongoing series on freedom of information laws. This session, we're going to focus on the open meeting law in Vermont. And with us is Leah Ernst. She is the legal director at the ACLU of Vermont, where she litigates civil liberties, civil rights, and open government cases. Leah, thank you so much for joining us today and leading us, walking us through the open meeting law in Vermont.
Yeah, thanks, Emily. I'm happy to be here as always. So to sort of situate the conversation, what we're going to try to answer today is it a meeting? If so, can you attend it? If there's an open meeting law violation, what can be done? And then we'll spend a little time at the end, if we have time, on some of the changes brought about by the COVID-19 pandemic. As an initial matter, it's important to note that the open meeting law is not a matter of public body's extension of grace or permission to the people. It's a constitutional mandate. So our Constitution provides that all power, being originally inherent in and consequently derived from the people, therefore all officers of government, whether legislative or executive, we'll get back to that part in just a second, are their trustees and servants, and at all times in a legal way accountable to them. So the open meeting law is simply the statutory implementation of that constitutional command. And the default, therefore, is that all meetings of a public body are open to the public unless an exception applies. So we'll dig in quickly to some of the nitty-gritty here. When you're asking yourself, can I go to that gathering, that meeting, that discussion, the first question you want to ask yourself is the entity holding that gathering a public body within the meaning of the open meeting law? And the OML, as I'll call it from here on out, defines a public body as any board, council, or commission of the state or of one or more of its political subdivisions, by which it means a municipality, a county, etc., or any board, council, or commission of any agency, authority, or instrumentality, again, of the state or one of its political subdivisions, or a committee of any of those things. That draws out an exception for Governor's Advisory Commission, which we saw during COVID. Governor Scott had appointed a COVID Advisory Commission. That was not, by definition, a public body under the meaning of the open meeting law. And now the legislature has said that under the language of the statute, it or its committees or subcommittees are not subject to the open meeting law. And it is true that the Public Records Act defines public agency differently and more broadly than the open meeting law defines public body. But there are at least plausible arguments on both sides, and the Supreme Court hasn't answered that question. So we'll just look at a few examples. A municipal select board is very clearly a public body within the meaning of the open meeting law, whereas the governor's snowmobile advisory commission, which yes, does exist, is not. It is just like that COVID-19 advisory commission, a gubernatorial commission that provides unfiltered advice to the governor. Okay, so we've got now, let's say we've determined it's a public body. Our next question to ask is the gathering a meeting? And a meeting is also defined fairly broadly. It is anytime there's a quorum of the public body, and the meeting is doing one of two things. One, It's discussing the business of the public body, which is defined as its governmental functions, including any matter over which that body has supervision, control, jurisdiction, or advisory power. So if you have a quorum and it's discussing the business of the public body, or you have a quorum and the public body is wanting to take action, then you've got yourself a meeting. Other gatherings, such as email discussions around setting an agenda, are not, but those records are subject, of course, to the Public Records Act. So you still have access to those records. It's just not a meeting within the definition of the OML. So a few examples here, I think, will illustrate the point. If two members of a 7-person city council happen to run into each other at the gas station, and they're at that point, they decide to agree how they're going to vote on an upcoming zoning ordinance. That is not a meeting. We don't have a quorum, even though it's, business of the legislative or the public body. We don't have a quorum. If the Vermont Board of Cheese meets in a dairy barn to debate a rule on pasteurization, sure, it doesn't matter where it's happening. It's just you've got the public body and they're discussing the business of that public body. If the entire school board gathers to have cake celebrating the birth of the superintendent's first child, nope, that's not the public business. That's not the governmental business. But let's say we have most of the solid waste district's commissioners trading emails about whether to raise taxes in the upcoming year. Sure, a meeting can happen over email, so long as you have a quorum and it's either taking action or doing the public's business. The last example I will give is, let's say a state administrative body holds a meeting to discuss American foreign policy. Even if every single person on that body is there, they have no jurisdiction over American foreign policy. So that is not a meeting within the OML. All right, so we've got a public body and there's going to be a meeting. What do they have to do to announce that meeting ahead of time? Well, we have a few different types of meetings. We've got regularly occurring meetings, which by statute their time and place must be established by statute, regulation, ordinance, or order of the public body. It's available to anyone upon request. So those are your regularly occurring, once a month or whatever the case may be, meetings. But the body can also hold special meetings, in which case they need to announce that 24 hours in advance. And municipalities must post announcements in the clerk's office and at least 2 other predetermined locations in the municipality. And then the last type of meeting, the emergency meeting, doesn't need any sort of advance notice, although it's always good practice to provide as much notice as you can. But these meetings can only take in very, very limited circumstances where an unforeseen occurrence requires immediate attention by the public body. So if the legislature passes a statute saying the Public Service Board meets the first Tuesday of each month in, office 412 at this address, perfectly legitimate. If a select board, however, wants to have its regularly scheduled Monday meeting on Saturday instead as an emergency meeting because the Red Sox could clinch the World Series on Monday night, no dice. That is not an emergency requiring the immediate attention of the public body. Nor is it an emergency to call a meeting because town meeting day is coming up fast and we haven't yet proposed a budget. Town meeting day is not an unforeseen occurrence. So, that I think spells out sort of the contours of what they have to tell you in advance. I think the most complicated and the most controversial part of the open meeting law is whether and when the body can go into what's called executive session, meaning they close out the public. To go into executive session, a municipal body must have a majority vote, a state body must have a 2/3 vote, and the vote must specify the subject of the executive session. And the subject matter of executive session is limited. It's only permissible to discuss certain topics and in certain circumstances. The most common justifiable reason for executive session is to discuss specified topics about which, quote, public discussion would clearly place the public body or a person involved at a substantial disadvantage. And the body must make a specific factual finding that discussion of this thing in open session would involve that substantial disadvantage. And so the topics appropriate for that sort of executive session include discussion of certain contracts, labor relations, litigation to which the public body is a party, and confidential attorney-client communications. There are a few other permitted topics for executive session that don't require this threshold finding of substantial disadvantage. This includes hiring decisions, disciplinary decisions, or evaluations of public employees, negotiating real estate transactions, discussing protected records of students, imminent threats to public safety. So those are the most common reasons to go into executive session. But even if you are properly in executive session, the body cannot take any binding action within that executive session. They have to come out of executive session and then take the vote publicly. The one exception to this is conducting real estate transactions. So again, a few examples I think will illustrate the point. If a select board goes into executive session simply because it has executive session as a standing part of its agenda, that is definitely not appropriate. You need to find a specific reason and state on the record why you're going into executive session each and every time, and then take the proper vote. If a school board enters into a real estate lease in executive session, yes, that's the one, as I mentioned, specifically delimited example where a public body can take action in executive session. Let's say a city council goes into executive session, and whenever anyone mentions the word lawyer, thinking, oh, that's lawyer-client privilege, we can go into executive session. That's just not true. The scope of attorney-client privilege is significantly narrower than simply anytime I want to talk about or to a lawyer. And then the last example would be a student who's appealing having been expelled from their high school, and they discuss that in executive session, leave executive session, and then take a public vote reversing the expulsion. Yes, that is the proper way to handle that scenario. You don't take the vote while still in executive session. Another way the open meeting law protects our rights to hold our public bodies accountable is by requiring that minutes be made available after the fact. In fact, within 5 days from the date of the meeting. If the public body has a website, the minutes must be posted to that website, and they must include the following information: the names of the public body's members who attended the meeting, all motions or proposals considered and the results of those motions or proposals, and the names of all other active participants in the meeting. So does this satisfy the minutes requirement? A town takes down its entire website rather than learn how to post them online. Unfortunately, yes, that's okay. And we have seen that happen, sadly, although, less so, I think, as it's pretty much expected that a public body will have a publicly accessible website, as it becomes, inexcusable to not know how to handle posting minutes in that way, but permitted under the law. If a school claims that they will make their minutes available to you in 5 business days instead of 5 calendar days, that is not what the OML requires, although there's substantial misunderstanding of that fact. It is, in fact, calendar days. And then let's just say a city sewer subcommittee says that only voters within that sewer district may inspect the minutes. That is definitely not permissible. Any person, Vermonter, not Vermonter, member of that district or otherwise, has a right to the minutes of any kind of meeting. So those are the contours of what's required of a public body to satisfy its obligations under the open meeting law. But what happens if you think there was a violation and you want to seek some sort of redress? Well, the OML sets out a couple of different paths. First of all, a public body or member thereof that engages in a knowing and intentional violation of the open meeting law has actually committed a misdemeanor that can have a $500 fine attached. Before 2014, the Attorney General or any person aggrieved by a violation of the open meeting law could bring a civil lawsuit. But the legislature in 2014 significantly amended the open meeting laws, making it much less likely that court actions will be brought to enforce it. They did this first by putting into place certain pre-litigation requirements that the person must satisfy before they can go to court. So if I thought that there was an open meeting violation, the first thing I have to do is provide that public body written notice of the problem and specify what I want that body to do to cure that problem. The public body then has 10 days to respond with whether it says, yep, you were right, that was a violation, and here is how we're going to fix it, or I disagree, there was no violation. And then you have to give them 2 weeks to do the actual fix. And so the fixes can take a couple of forms, but if they had taken some sort of action, they voted on something in executive session that wasn't a real estate transaction, for example, or they wrongfully excluded someone from the meeting or had failed to give proper notice of the meeting, any actions or votes taken under those circumstances, they would either have to subsequently ratify in an open meeting that complies with all the rules, or void those actions altogether and start at a clean slate. So they have to do that, but then they also have to adopt measures to prevent future violations, and those measures have to have the actual effect of preventing future violations. So that often looks like remedial training for the public body on what the OML requires. So if after you've provided this notice, they responded within 10 days and either said, I disagree, there was a violation, or you're dissatisfied with the cure that they have adopted, then and only then can you file suit in court seeking a court ruling that the OML had been violated. But unfortunately, the way that the open meeting law is set up, it's very, very difficult for even a successful plaintiff to recover court costs and attorney's fees, which makes it less likely that the private bar is going to be willing to bring these enforcement actions. We see a very strong distinction between the open meeting law and the Public Records Act. The Public Records Act says a prevailing plaintiff shall be awarded their reasonable costs and attorney fees. So if a public agency violates the Public Records Act, there's an incentive for private attorneys to help people vindicate their rights under the Public Records Act, because if their case has merit and they win, the agency will have to pay their attorney fees and costs. But unfortunately, that is not true of the open meeting law, which is, I think, why you'll find there's just a lot less case law on the open meeting law than the Public Records Act out there. So a lot of its contours remain undefined. So that's the long and the short of the open meeting law. I think I'll just end quickly by describing some of the changes that have been brought by COVID. So as of early in the pandemic, and then at least as of now through January 15th of 2023, there are special rules that allow agencies to do, our public bodies to do things a bit differently during COVID. And, they make some sense, right? It's not everyone is meeting in person, for example. And so if the public body doesn't have to meet in person, which is true pre-COVID and now COVID, but they also do not need to provide a physical location for the public to attend. Where it used to be the case, even if a body was meeting electronically, they still had to say, but if you want to watch the stream, you can come to City Hall or this place or that place and participate. They no longer need to provide that physical location for the public, but they must use technology allowing the public to attend electronically or also to just call in by telephone. So they can't just move to an electronic meeting as a means of making public access more difficult. They're also required to record any such meeting, barring unusual circumstances that make it impossible to do so, which I'm not sure what those would ever be. They can take a little more time to make their minutes available. They can go up to 10 days if and only if there's a COVID-19 related staffing shortage. And then finally, I mentioned at the beginning, they have to post notice at the clerk's office and 2 pre-designated locations. They can replace those pre-designated locations, one or both of them, with electronic postings, but they still must physically post the notice of the meeting at the clerk's office, and then also provide a copy of that notice to the town's newspapers of general circulation. So these are all, I think, fairly common sense approaches to making sure, in a time where people are not gathering in large groups as much, or, for some folks, it might be simply too risky to gather in person, they are still able to take part in the oversight process of our government. And I think that's what I have for you all.
Leah, thank you so much for taking the time to lead us through this.
Thanks, Emily, as always, for hosting these. I appreciate it.